it's very clear that the Establishment Clause was meant to prohibit the federal government from establishing a national church, such as the Church of England. Interestingly, the Bill of Rights, which includes the First Amendment, of course, was meant to constrain only the action of the federal government. So, circa 1791, when the Bill of Rights became law, the federal government was prohibited from establishing a national church. But state governments were free to establish their own official church. And that changed with the enactment of the 14th Amendment in 1868, which prohibits states from denying individuals due process of law. And the Supreme Court has interpreted the 14th Amendment's due process clause to encompass the First Amendment, including its protections of religious freedom. So in today's world, this is so familiar that really it doesn't need saying, but in today's world, not only is the federal government prohibited from establishing a national church or religion, but state governments are likewise prohibited. Another thing that's clear from history is that the Establishment Clause prohibits government imposing taxes for the use and benefit of a particular church. So the history here is that Virginia had an official church, and the legislature of Virginia imposed a tax on the citizenry for the support of this church. And in 1785, John Madison wrote his famous memorial remonstrance, in which he objected to this compulsory tax for the benefit of a particular church. And then in 1786, Thomas Jefferson authored the Bill for Religious Freedom in Virginia, which likewise prohibited the government from imposing a tax for the benefit of a particular church. So ever since then, it's clear that the Establishment Clause, which was originally authored by James Madison, was meant to prohibit both the establishment of an official governmental church and also compulsory government taxation for the benefit of a particular church. Some aspects of history are controversial. The historical evidence is mixed. So one area has to do with legislative chaplains. The very first Congress hired an official chaplain to open its sessions and paid the chaplain with government funds. And Madison's view was that this was an unconstitutional establishment. So there's an instance where we have prominent founders on both sides of the issue. Is it an establishment for Congress to hire an official chaplain to open sessions? Prominent founders in Congress voted in favor of doing so, but James Madison, the initial author of the First Amendment, objected on the grounds that this would be an unconstitutional establishment. And ever since the first Congress, subsequent Congresses have hired an official chaplain, paid by government funds. President George Washington issued a proclamation declaring a day of thanksgiving and prayer. And President Jefferson, who wrote the Bill for Religious Freedom that was a precursor to the First Amendment, refused to do so when he was president on the grounds that this would constitute an unconstitutional establishment, governmental endorsement of religion. And Jefferson's view is that government ought to stay out of religion to the extent possible. Madison's story is kind of interesting. When he was president for his first 3 years, he refused to issue a proclamation for a day of thanksgiving and prayer. But then he relented, and in retirement, he expressed regret for relenting on the grounds that the government declaring a national day of prayer constitutes an unconstitutional establishment of religion.
Question?
Yeah.
So when Are those people compensated in any way? How does that not promote one religion over another?
Yeah, so I'm not exactly sure how that works. You know, whether the president-elect selects his own chaplain, in which case the chaplain wouldn't be paid with government funds, or instead the president-elect uses either the House or the Senate's official chaplain, who is paid, who is on the governmental payroll. Yeah, so I guess you're asking, gee, would this constitute an unconstitutional establishment? Right. And the view of Jefferson and Madison might be yes. This is an unconstitutional commingling of government and religion. But the defense of that, well, I can think of two defenses. One, it's within the tradition of legislative prayer. You know, just as Congress and the Senate can open its sessions with a religious prayer said by an official chaplain paid with government funds, so too can a president-elect inaugurate his election and ascendance to the presidency with a prayer, even if the prayer is done by a governmentally paid minister or chaplain. And then the other defense would be, you know, when legislators take office, they don't shed their First Amendment rights. They are also private citizens and entitled to engage in expression, both of a political nature and a religious nature, as a private individual. So you could say that that's what's going on as well. Okay, so I wanted to talk about several contexts in which the Establishment Clause arises in contemporary times. So one is governmentally mandated or sponsored prayer. So on the PowerPoint slide, I have an image of prayer in primary schools. And in a case called Engel versus Vitale in 1962, the U.S. Supreme Court invalidated a New York law that required that prayer be said at the outset of the school day in all primary and secondary schools in the presence of a teacher. Also, I have an image of high school graduation. Actually, it looks like a college graduation, but Lee versus Weissman invalidated a governmentally sponsored prayer in which the government, the school, had a hand in controlling the content of the prayer at high school and junior high graduation ceremonies. Another context has to do with religious symbols. So displays of religious symbols on governmental property. Stone versus Graham overturned an Alabama law requiring that the Ten Commandments be displayed in all school classrooms. In Van Orden versus Perry, the Supreme Court upheld a display of the Ten Commandments on the grounds of the state capitol in Texas. And interestingly, the frieze on the U.S. Supreme Court building depicts, among other things, Moses with the Ten Commandments, as you can see in the picture. Of course, it displays a lot else. It's devoted to depicting lawmakers throughout history. But one of the lawmakers is Moses receiving the Ten Commandments. And then there's governmental aid to religious institutions. So the case here is the Zellman case, in which the Supreme Court upheld a school voucher system in Cleveland, Ohio, where parents were free to use the voucher at whichever private school they wished. As it turned out, about 95% of the parents chose a religious school. Okay, so let's talk about some basic concepts that the Supreme Court has used throughout its history in resolving Establishment Clause issues. So nobody endorses complete separation of church or state. So if you take complete separation of church or state to its logical conclusion, you're led to conclusions like it's an unconstitutional establishment for the fire department to send out fire trucks when a church is on fire. Nobody endorses that position. It's unconstitutional for the government to send out police when there's some sort of violent fracas in a church. Nobody endorses that position. Or it's an unconstitutional establishment for private individuals to voluntarily pray in governmental buildings. So prosecutor, before entering the courtroom, stops and says a silent prayer to help him or her with the case. Nobody takes the position that that would be an unconstitutional establishment of religion. So if there's no complete separation of church or state, the question becomes, where do we draw the line? Many of the justices look to history for guidance. There's a case of Marsh versus Chambers involving Nebraska's practice of, just like the very first U.S. Congress did, hiring a legislative chaplain to say an opening prayer before each legislative session. And the Supreme Court said, all we need to do is look at historical practice. And we find that from the very early days of the Republic, this has been treated as permissible. The first Congress, which included lots of prominent founders, voted in favor of this, and every Congress since then. So we don't have to look any further than history. All of the justices agree that whatever else it prohibits, the Establishment Clause prohibits the government from coercing religious practice. And some justices, such as Justice Thomas, would limit the meaning of establishment to coercion. So we can ask ourselves, well, what about prayer in primary and secondary schools? Is that coercive? And the Supreme Court in Engel, among other things, said, yes, we think this is a coercive practice, that the New York law requiring secondary and primary students to recite a prayer in the presence of the teacher, even though individual students may opt out if they wish, is coercive. And I think key here is the primary and secondary context. The primary and secondary school context of the prayer. So, would a first grader feel free to opt out of a prayer in which the overwhelming majority of students participated? Kids that young are susceptible to peer pressure and also pressure from authority figures, such as teachers. You could say, well, having students recite a prayer or sit silently while prayer is occurring doesn't really amount to participation in the prayer. There's a difference between participating and expressing respect for others. But kids who are very young have difficulty appreciating the distinction between reciting a prayer or sitting silently, standing just out of respect. So, I think there's a lot to be said in favor of the conclusion that prayer in secondary and primary schools has a coercive element to it, even with an opt-out. Another case involving coercion is the Lee versus Weissman Case, which I mentioned earlier. So here, school principals invited clergy to give a prayer. The school exercised some control over the content of the prayer at junior high and high school graduations. And everyone stood while the prayer was being recited. So was this coercion? And a majority of the justices concluded that it was. So the rationale was that everyone agrees that the Establishment Clause prohibits coerced participation in a religious exercise, such as prayer. And the coercion here is that, look, this is graduation. It's a milestone in a person's life. As a matter of social practice, attendance at graduation is compulsory in the sense that it's not a reasonable choice to offer students the option of not attending graduation at all. And since we're dealing with young kids, they are less able to understand the distinction between standing out of respect for the religious views of others and participation. And there was a dissent. Justices Thomas and Scalia dissented, and they agreed with the principle that the government may not coerce participation in prayer. But what they disagreed with was the majority's conception of coercion. Look, the kind of coercion that the Establishment Clause is concerned with is legal coercion, some kind of official sanction or punishment. So if students had not stood to participate, it's not as though they would have their grades diminished or they wouldn't be allowed to graduate. There was no legal consequence associated with dissent. So the kind of coercion within the meaning of the Establishment Clause was not present. What about legislative chaplains? And here I think you can think of good reasons to distinguish prayer in primary and secondary schools and prayer at the opening of a legislative session. So legislative session, we're dealing with mature adults, legislators. And they've been elected because they have strong views about things. So they are better able to appreciate the difference between standing out of respect for the religious convictions of others and full-blown participation in a religious exercise. Also, legislators are more likely to opt out. So if you've ever been at the beginning of a legislative session, a lot of legislators aren't even present. A lot of legislators are kind of milling around. It's very much unlike the opening of a school day where the teacher assures that the students are seated and so forth. So this quote is drawn from a decision involving a town in New York that opened its city council meetings with a prayer. And it turned out that virtually all of the clergy who recited the prayer were Christian clergy. And the question was whether this was a violation of establishment. And the court distinguished the Lee versus Weissman case. It said, quote, mature adults presumably are not readily susceptible to religious indoctrination or peer pressure. So in law school, we fill our discussions with hypotheticals, some of which are hopelessly unrealistic, but they're designed to illustrate a conceptual point. So one of the hypotheticals that I like to use is, let's say that the government put up a billboard along, say, I-70. And the message on the billboard was, Catholicism is great. I think obviously that wouldn't violate the coercion test. There's nothing coercion about telling people as they're driving along that Catholicism is great. There's an argument that this would violate the Establishment Clause, but it wouldn't be based upon the coercion test. This is just kind of a non-coercive message of approval. Okay, so another test that the justices have used is an endorsement test. So on this view, not only may the government not coerce religious belief or practice, but also the government may not endorse either a particular religion or, in the view of most of the justices, may not endorse religion generally over irreligion. So we can ask ourselves, well, what about school prayer? Apart from coercion, does this constitute a governmental endorsement of prayer? In Engel versus Vitale, this is one of the rationales that the Supreme Court gave for striking down the New York law requiring the reciting of prayer in primary and secondary schools. In the view of the court, it amounted to a governmental endorsement of religion. What about our billboard, Catholicism is great? I think this would violate the endorsement test. It's not coercive, but the government is endorsing a particular religion. And under the endorsement test, the government may not do that. Let's say that change the wording on the billboard. So the billboard says, not Catholicism is great, but rather religion is great. Worship regularly at the place of your choice. Would that constitute an endorsement? So this is a little bit tricky. So all of the justices have agreed that what the government may not do is coerce, or many justices may not endorse a particular religion over others. You might recall a case involving executive order promulgated by former President Trump, which prohibited persons from certain countries from entering. And one of the issues in that case was whether the executive order was motivated by animus against Islam. And all of justices agree that government may not put its thumbs on the side of one religion as opposed to other religions. So if the justices had concluded that the executive order was motivated by Islamophobia, then they would have struck it down. What about favoring religion generally over irreligion? The justices have disagreed about this question. A minority of justices have said, no, the Establishment Clause doesn't forbid this. It's okay for the government to endorse religion generally over irreligion. But a majority of justices through time have taken the position that it's a violation of establishment for the government to put its thumbs on the side of religion generally as opposed to irreligion. And this is kind of interesting because it gets into the question of what qualifies as a, quote, religious belief, unquote, within the meaning of the First Amendment. So are the views of atheists that God does not exist religious for purposes of the Establishment Clause? The view that the government may not put its thumbs on the side of religion generally can be seen to implicitly rest on the conclusion that all views about the existence of a sacred transcendent being, whether they affirm the existence of such a being or deny the existence of such a being, are religious for purposes of the religion clauses. Okay, so I wanted to close with a discussion of the Supreme Court case that is upcoming. So the case involves a high school assistant coach who says prayers, or until he was terminated, he said prayers at the middle of the field immediately after the game. So he filed suit, alleging that this was an abridgment of, among other rights, his free speech and free exercise rights. The case went up to the United States Court of Appeals for the Ninth Circuit. The Ninth Circuit said that what the coach did constituted an establishment of religion. Therefore, the school district was justified in doing what it did, and he doesn't have a claim. And just this week, the U.S. Supreme Court agreed to hear the case. So, you know, we can.
What was their basis for hearing it?
Yeah. So I mean, there's kind of an interesting backstory. The case initially was decided by the U.S. Court of Appeals for the Ninth Circuit, and the Ninth Circuit said that he didn't have free speech rights at stake because his prayer was part of his speech as a public employee rather than a speech as a private citizen. So he asked the U.S. Supreme Court to take the case down, and the Supreme Court said, no, we need to know more about the facts. But four justices wrote an opinion saying, yeah, we're not going to take the case now, but we're pretty sure that the Ninth Circuit got it wrong. So the case went back to the Ninth Circuit. And the Ninth Circuit kind of doubled down on its rationale. And the Supreme Court just this week granted cert. Now, when the Supreme Court decides to hear a case, you know, of course, it's not required to decide cases. You have to petition the Supreme Court for review. And when the Supreme Court grants the petition for review, it doesn't state its reasons. So we don't have an official statement of why the Supreme Court decided to take the case. But based on the earlier history of the case, we can be pretty sure that four justices think that the Ninth Circuit got it wrong. And they want to take the case to correct what they view as an egregious error. Okay, so yeah, it's kind of a fuller description of the facts. He was assistant to the varsity high school football team, head coach of the junior varsity team, and before the game, he led the players in a pregame prayer. And then after the game, you know, the players go to the middle of the field, they shake hands, you know, good job, great game, whatever. And he used that opportunity to kneel down and say a prayer. So the school district said, hey, we have a policy against saying prayers when students are present, so you can pray in private, but what you're doing is prohibited by our policy. And he said, no, I think you're wrong. He continued to pray, and this began to attract a lot of publicity. So many of his own players, most of them, prayed with him at the center of the field. And eventually, players from other teams and fans as well would come down to the middle of the field to pray. So the school district said, In our view, what you're doing constitutes an unconstitutional establishment of religion, and it refused to renew his contract. And as you might imagine, this attracted quite a lot of national publicity. I guess I hadn't heard about it until this week when I saw the Supreme Court granted certiorari in this case. Had any of you heard of this case? Yeah, I mean, it was in Washington. But I think the practice of post-game prayer is not all that unusual. My wife and I graduated from the University of Michigan, so I'm a Michigan football fan, and we went to Lincoln, Nebraska, to see my beloved Michigan Wolverines play the Nebraska Cornhuskers. And I noticed that after the game, quite a number of Nebraska players went to the end zone and they knelt and they prayed. So I don't know, what's your experience? Have you seen this before? Yeah. Yeah, I don't think it's all that unusual.
Could the argument be made that once the game ends, you become a private citizen again? That you are no longer praying within your job duties. This is what you're doing after the job is done. Yeah,
that's a very perceptive point, and that's a crux of one of the disagreements in the case. So the Ninth Circuit panel, the way the U.S. Court of Appeals work is they sit in 3-judge panels. So the 3-judge panel concluded that the prayer was not his speech as a private citizen. Rather, it's part of the job responsibilities for the players and the coaches to go to the middle of the field, shake hands, congratulate the other team on a game well played. And that's when the prayer occurred. So the Ninth Circuit majority said it would have been different if he had gone out to the field after the players and the fans had left and then had knelt to say a prayer. Or the school district offered him space in the booth above the stands. Look, if you want to go up there and pray so that it doesn't occur immediately after the game in full view of everyone else, that would be fine with us. But the case, sometimes in important cases, the full panel of judges on the Court of Appeals will agree to rehear the case. So one of the judges on the U.S. Court of Appeals for the Ninth Circuit asked to have the case reheard by the entire court. And I'm not sure how many judges there are on the U.S. Court of Appeals for the Ninth Circuit, probably 15 maybe. So the majority voted against rehearing the case, but there was a dissent. And the dissent took the position that you were articulating, which is that this is speech of a governmental employee as a private citizen. So it would be akin to a teacher in the cafeteria bowing her head and saying a prayer before eating a meal. No one would contend that that's an establishment of religion. Yeah?
But could it also be a coercion in that you think if I don't do this, my coach isn't going to play me the next game?
Yeah, that's another issue in the case. So the Ninth Circuit panel, 3-judge panel, mentioned that the district court, the trial court, had found that one of the players, an atheist, testified that he participated in the prayer not because it expresses his religious views. He's an atheist, but rather because he was concerned that he would lose playing time if he didn't participate. So, this brings up the coercion test. All of the justices on the Supreme Court agree that government may not coerce participation in religious practice. So, was this coercive? The panel of the Ninth Circuit said yes. The judges who dissented from rehearing the case, the decision not to rehear the case, said, oh no, he didn't ask any students to participate. They just started participating on their own, as did players from other teams and eventually fans. So this was all voluntary. It was not coercive. The Lee versus Weissman decision has some bearing here. Lee versus Weissman involved prayer at high school graduations, and it said that there's kind of implicit peer pressure at work here that must be taken into account in deciding whether coercion was involved.
I mean, I can see the same thing, almost the difference between high school and college, when you brought up college.
Yeah.
There's that level of maturity, and then college to professional, again, the change of maturity or how much power, I guess, you have as a player.
Yeah, right. Yeah.
I have a question. So I find it interesting that they're distinguishing after the game, but when a player is hurt during a game, it's customary to take a knee. And there is usually lots of prayers going on both sides, in the stands on both sides of the sideline. So I'm wondering if that will have an impact on the ruling.
So a player gets injured,
Right.
And then a prayer is said?
Well, it's customary usually to take a knee, like in respect and honor of that player to find out what happened, and there's always prayers at the sidelines and in the stands.
Yeah.
But
Yeah.
But not like public.
But that's player-led, it's not the coaches saying, let's all.
Well, I don't think in this case that the coach ever said, let's all gather. He went out there, he started praying. After shaking hands, he went to a separate part of the field. My understanding of it, he started praying, and some of the players then started. And after a period of time, they got to be more and more people gathered with the coach. It wasn't something the coach said, let's go do this. He did it, they started following.
Yeah, but why do we take a knee in the middle of the game, though, when a player is hurt?
I don't know that's necessarily.
Because there is.
Right. But
Yes.
I think this could be different, like if the players said after the game, we want to pray, maybe invited the coach, I think possibly that would have led to a different result than where we're at with this case.
There's another potential arguable difference. So, when I think about injuries and players kneeling down, there's a moment of silence. Nobody is saying anything. But the coach here was reciting a prayer, and he's a devout Christian, so the prayer was Christian in orientation. And the way this evolved is that it not only included prayer, but he would give a motivational speech as well that included religious themes. So I suppose you could distinguish what you're talking about from what happened in this case on that ground as well. I think it's pretty well agreed among scholars at least that a moment of silence requirement in, say, primary and secondary schools would be constitutionally okay. And that there's a difference between a moment of silence on the one hand and a governmentally prescribed prayer on the other. Up there on the board, I have the 3-judge Ninth Circuit panel's principal reasoning, which appealed to the endorsement test. Any objective observer would view the district's allowance of that activity as stamped with the school seal of approval. And then the dissent says, what the heck? A reasonable observer would know that the district did not endorse the prayer because the district sent a letter to parents and staff saying, hey, what Coach Kennedy is doing doesn't reflect our policy. In fact, it's contrary to our policy. So given that, how could a reasonable observer confuse Coach Kennedy's prayer with the school district. Okay, so who do you think has it right? Any thoughts on that? You know, was the coach entitled to do what he did? Was the school district's response a good response? You know, wholly apart from the Establishment Clause, if you had been a school administrator, how would you have handled this? Would you have done it in the way that this Washington school district did, or would you have done it differently?
It's a violation of policy. He's admittedly violating policy, so they could remove him, I would think, for that reason, not rely on him.
Yeah, although the policy, you know, precluded him from doing this. So if he was constitutionally entitled to do what he did, then the policy has to give way, because the policy itself is unconstitutional. So last week I talked about the free exercise guarantee. And under existing law, a discrimination test is used. So when the government discriminates against religious practice as such, it's a presumptive violation of the free exercise guarantee. And here it's clear that the district wasn't prohibiting him from giving a secular motivational speech at midfield after the game. It explicitly singled out religion for differential treatment. So one of the issues in the case is whether this is a violation of his free exercise right. You know, another issue has to do with freedom of speech. So suppose that the coach, instead of going to midfield and saying a prayer, had knelt down in support of the Black Lives Matter movement. You know, I mean, a lot of football players kneel down during the national anthem before a game in protest of, among other things, racist criminal justice practices and policies. So, you know, if that's okay, then doesn't it involve viewpoint discrimination? You know, the government saying, we're going to punish your message because we don't like its content, which is a free speech no-no. So that's another issue in the case. I don't know, what do you think? You know, if you play Supreme Court justice, how would you decide? Yeah.
My guess is that it's going to come down to the fact that it's a secondary high school. So going on that maturity piece. And then I think too what will be relevant in the debate is what Andy was talking about in terms at what point is it not, you know, is he doing what he's doing as a private individual and students have followed post the game? I think it'll be interesting to see how they look at that, as well as, I mean, they have to debate over the district's policy. And it may be that, again, then it will be a debate over application of that policy and its reach. It'll be fascinating to see where they go.
What kind of precedents are there for the Ninth Circuit? I mean, are there similar cases that have been decided that they're basing this?
Oh, so the Ninth Circuit relied principally on a case involving Supreme Court decisions striking down a school's broadcasting prayer over its intercom system during the school day. And I think you can think of quite a number of reasons to distinguish that case. It's not the closest precedent. Yeah?
I'd ask you to dial back one slide, please. And I'd like to call to your attention the use of the word pugilistic in describing the coach's efforts to generate publicity. That's a pretty emotionally charged word to be used by a court of appeals. But if it's accurate, I think therein lies the concern that this guy is not simply encouraging, but he is demanding, he is at least enticing others to perhaps his view of religion. And that, for me, is a problem.
Yeah. That's interesting because the petition for writ of certiorari asking the U.S. Supreme Court to review the case focused in part on this term pugilistic. And they used it for exactly the opposite purpose. So the argument is that, look, he has free speech rights. The free speech right is a right to be pugilistic in one's speech, to passionately, aggressively state one's views. And the free exercise guarantee, it's not a right to exercise your religious views in a dark room where no one can see. It's a right to exercise your religious views proudly in the public sphere.
Well, that goes then to the question of whether the use of the term pugilistic was hyperbolic, or was it in fact associated with violence or pushing, shoving, etc., instead of just proclaiming. I don't think they would have used that word quite so carelessly.
Other thoughts? Well, yeah.
Was there any discussion in the Ninth Circuit of the employment law aspect of this? Here you have an individual that's employed with public funds, and the employer has some right there to say religion stays clear out of that scope of employment.
Yeah. Yeah, I mean.
What did his contract say? I'm a union person, so what did his contract say?
Yeah, clearly the school district was upset with the insubordination. They had given him marching orders on several occasions, and he had defied the marching orders. But the question is whether the marching orders were themselves unlawful. So you can't tell employees, look, you can't express your political views in a way that doesn't interfere with the performance of your job.
You can't when you're on the clock of the employer.
Yeah. So, in closing, I'll give you my brief thoughts. I'm much more troubled by the pregame prayer. That has a coercive aspect because the football players are there. It's not like they can get out of the room. It's kind of implicitly coercive. And if I had been on the school district, I think I would have, instead of telling him, no, you can't do this, tried to accommodate him in some way. Because interestingly, this whole controversy became, attracted national news, and it promoted the very divisiveness that I think the religion clauses are designed to avoid. You could blame that in part on his pugilism, but you might also think, as I do, that the school board contributed into making this an issue that divided the community. Anyway, it'll be...
I thought on one of the previous slides it mentioned that they tried to offer him an alternative location or something like that.
Yeah, but the alternative location was to do it in a black room where nobody can see. We don't tell players who are expressing alliance with the Black Lives Matter movement, oh, that's okay, you just have to do it in a black room in secret where no one can see. Yeah.
Was coaching his only role within the school district, or was he an educator as well?
I think he was just a coach,
Okay.
as far as I can
Because
determine.
I would have seen that being another piece of the puzzle, is if he
Yeah.
was an educator, but only his coaching license or his coaching contract was not renewed, but he was still allowed to be an educator. Why the difference in behavior between the classroom and the field?
Right. Well, thank you very much.
Thank you.
It's been a pleasure.